I'm Stephanie Fosh. I'm the Managing Director of a company called Pure Human Resources, and today we're going to be talking about dismissing people from your business. So dismissing people from your business is always something you should take some advice on in every circumstances. We get lots of calls from clients saying, can I safely dismiss somebody with less than 2 years service? And on the surface, relatively speaking, this is probably a lower risk to your business than most circumstances. However, if anybody rings up and asks that question, the first thing we're going to do is actually respond with some questions. So we need to make sure that somebody doesn't have some protection under the Equality Act, that actually they may not need 2 years service to be able to bring a claim against you in an employment tribunal. So my advice would be to take some advice in all circumstances and not just make the assumption because the person has less than 2 years service that there's no risk. Employees within your business have a number of rights, actually from day one of employment, even before they join as applicants as well. So one of the things to be really mindful of is particularly the area of discrimination legislation. So employees have a right to not be subjected to any form of discrimination for what are called 9 protected characteristics. So that could be age, sex, race, religion and belief or disability. So lots of rights, everything from working time through to holidays and so on. So certainly it's an area that most business owners should get some training in and be familiar with. It's really important that when you dismiss somebody from your business that you do give them a reason, and that doesn't need to be kind of war and peace in terms of a huge letter explaining details in great amounts of detail, but certainly with that's a reason for failure to pass probationary period or attendance, whatever it might be. Certainly something in writing to confirm the reason for termination is really important. We hear this phrase instant dismissal quite a lot. It's a very odd concept because actually in no circumstances can you ever instantly dismiss somebody, even if you have a case of something called gross misconduct, which is where it's really obvious because the behaviour of the individual has been so bad that it's likely to result in something that was gross misconduct under your company policy. You're still going to have to go through a process. So even if it looks and feels like the employment relationship has broken down because somebody's been so bad, so naughty, their conduct's been so inappropriate, you still need to go through a process that's in line with your disciplinary procedure, which should be based on the ACAS Code of Practice. So typically speaking, that's going to mean writing to the individual, inviting them to a meeting, giving them notice of that meeting. So typically we'd say 2 working days, giving them the right to be accompanied by another person. Again, typically that would be a fellow work colleague or a full-time trade union official, having the hearing and then following it up with the right of appeal. So just because it looks on the surface as though it's all cut and done does not mean that you can suddenly give notice or dismiss somebody on the spot. Unfair dismissal is a claim that an employee can bring against you and your business. Essentially, on the whole, this means an employee has to have 2 years service currently to be able to bring a claim. Certainly in my kind of career, we've seen the changes where 2 years has been moved down to 1 year, back to 2 years again. So people shouldn't assume that it's 2 years forever. Based on kind of change of government, we may see a change in that arena. But typically speaking, an employee who has more than 2 years service has more protection should you decide to end their employment than somebody under 2 years, as long as we kind of take out or remove the kind of piece around equality and diversity and discrimination legislation. Constructive dismissal is a phrase that we hear bandied around quite a lot. For somebody to have been constructively dismissed, they have to physically have left your employment. So actually, this is usually where the employee makes the decision to end the employment relationship, but they do it on the basis that they feel they had no choice, that they were forced to by their employer. So they will have had need to leave, and normally, typically for a constructive dismissal case to be proven or supported in terms of an employee front, it does mean that they need to physically have left and quite often without giving notice. So constructive dismissal can occur when the employer has done something that's really untenable, that feels the employee can't continue with the employment relationship and they physically get up and walk out of the business, or it could be a series of events that combined. The last event is just the kind of the straw that broke the camel's back and the employee feels they can't return to the workplace, and so they leave, and then they can bring a claim feeling rejected by the employer, and therefore that they are warranted in terms of that response that they can give. Wrongful dismissal doesn't occur very frequently, but typically it's likely to occur when there's a breach of contract. So it could be, for instance, you dismiss somebody and you don't give them the appropriate notice period, either as per their contract or their statutory terms, or you fail to pay them for something that that they're entitled to as part of that process. If you're in the situation where you've got a probationary period built into your contract of employment, typically that's 3 or 6 months, and you feel that somebody is not performing and you need to leave them, let them go, then it's really important that you actually communicate that to them. Hopefully in the first instance, if you have a conversation, you feel that you can get them to the required standard of performance. But obviously if you can't and you do need to dismiss them, that would typically be by what we would call kind of a review of probationary period. So you could leave it until the end of the probationary period, or if it's really severe and they're unlikely to meet that target, then it could be partway through that process. And as a minimum, just courtesy, goodwill, you should obviously arrange to meet with the employee, give them some feedback, and then obviously confirm everything in writing to them. Typically, there is no such thing as retirement any longer in UK employment law. We used to have a contractual retirement age, or an age that most people could put in their contract of employment that required employees to retire, which typically was around 65. And with the introduction of age discrimination a number of years ago, that was actually removed. So whilst employees may still have that in their contract, ideally they shouldn't, because they should have had a new contract since then, actually there's no such thing as retirement. If somebody wants to leave your business, they're technically resigning, and they should be treated like any other leaver, although I appreciate obviously it's quite an emotional process for them. But certainly you can't say to somebody, you've reached the age of 70, I'm now retiring you from the business. If you feel they're not performing, then the options available to you would be for something like a capability process, which would be around expectations around their performance of the job that you need them to do.